So welcome everyone who's joining. We have about 21 participants on the call right now, waiting for a few others. Those who are trickling in, my name is Ali Karpel. I am the Women of Reform Judaism Religious Action Center Reproductive Health and Rights Campaign Associate. We're so glad you're joining us for this timely webinar. We're going to give it about 1 more minute before we jump into today's webinar. All right, it looks like folks are still trickling in, but in an effort to keep us on time, we have a very action-packed agenda. I just want to go over some webinar best practices, some how-tos, in case you're unfamiliar with this technology. Everyone who is an attendee of this webinar, meaning you're not a panelist, your video will be off, but we still are very interested in hearing what you have to say. Please feel free to use the chat function at the bottom right of your screen. You can choose if the chats are sent to myself or to all panelists, I believe. You have the ability to send to just myself or to specific panelists or myself. I'm going to ask that any questions either get sent to all panelists or myself, just to make sure that we all can field what questions are coming in. You also have the ability to click on Q&A, which is in the bottom center of your screen. I will be checking both locations throughout the webinar. We will have a designated time for Q&A towards the end of today's webinar. So if we're not pausing to answer your questions, don't worry, we have time set aside. Without further ado, I'm going to turn it over to Rabbi Marla Feldman.
Hello, everyone. Thank you for joining us. As Ali just said, I'm Marla Feldman. I'm the Executive Director of Women of Reform Judaism. I'd like to begin by giving you just a little bit of context about how and why we're here and Ali is there doing what she's doing in Washington. Starting really in the spring, winter and spring last year, we started to see a lot of activity around legislation that would limit access to reproductive rights, egregious legislation in Alabama and Georgia, the fetal heartbeat bills, and some other legislation that would really inhibit women's access to reproductive health services. And we knew, we being Women of Reform Judaism, as well as the Religious Action Center in Washington, that we needed to ramp up our advocacy efforts and help our community mobilize around these issues and connect with coalitions working on them. Some of you on this call may have been at the consultation on conscience last spring, and it was front and center, this topic and the issues. So you also would have heard at that time the announcement of the Brit Olam cohort, which is part of several a group of several cohorts being facilitated by the Religious Action Center. This cohort on reproductive health and rights is being co-led by WRJ and the Religious Action Center. And in an expansion of that, we have established the Reproductive Health and Rights Campaign, which is being staffed by Ali, who you just met a moment ago. So with a special fundraising effort from WRJ, we were able to fully staff this position. And with Ali on board, what she's been able to do is really remarkable. We have a congregational toolkit. Some of you may have been at the recent URJ biennial. There was a learning session there. Ali has been speaking all over North America on these topics. And helping our congregations, our sisterhoods, particularly in those states where there's a lot of activity, to connect to coalitional efforts. In some cases, those are efforts to pass positive legislation, and in some cases, those are efforts to block negative legislation. So that's a bit of the backdrop to this webinar. Tomorrow, I think many of you know, is the anniversary of Roe v. Wade, so we thought this would be a really timely opportunity to let all of you know about the most current pending case before the Supreme Court, and that's, of course, June Medical Services case that we're talking about today. A little bit of another word about what Allie has been doing. You see that engagement around this case in particular. We're part of a broad coalition of healthcare providers, civil rights organizations, faith organizations who are all working very actively to oppose the restrictive bill in Louisiana and to encourage with briefs, amicus briefs, the Supreme Court not to uphold that legislation. So for our webinar today, I'm going to introduce our two speakers. I'm going to introduce both of them, and then I will turn it over to them one at a time to offer their remarks. Our first speaker will be Rabbi Lexi Erdheim. She's the assistant rabbi at Congregation Gates of Prayer in Louisiana. She's also the director of the Staff and Training Program at URJ Henry S. Jacobs Camp in Mississippi. Lexi received her rabbinic ordination and nonprofit management degrees from Hebrew Union College in Los Angeles. And Rabbi Erdheim will be leading us in a text study in just a moment. Our second speaker will be Elizabeth Smith. She joined the Center for Reproductive Rights in 2018. She's responsible for overseeing the center's state and local policy and advocacy program within the United States. Her work includes developing, implementing, and managing the center's multifaceted reproductive rights policy initiatives and strategies aimed at moving proactive policy strategies forward and preventing abortion restrictions in these states throughout the United States. So with that, I'm going to turn it over now to Rabbi Erdheim, who will lead us in a bit of text learning.
Thank you, Rabbi Feldman. So I am honored to be here to provide some of the Jewish perspectives on abortion. We'll begin, Ali, if you can move to the next slide, please. We'll begin, as we do any study of Torah, with the blessing for the study of Torah. Baruch atah Adonai Eloheinu melech haolam, asher kidshanu b'mitzvotav v'tzivanu la'asok b'divrei Torah. Blessed are you, Adonai, our God, sovereign of all, who hallows us with mitzvot, commanding us to engage with words of Torah. Next slide, please, Ali. Thank you. So to frame our conversation, well, first I want to put out a brief warning that some of these texts are very raw and a little bit graphic and can sometimes come off as cold and unfeeling when it comes to the topic of losing a fetus or an abortion and things like that. So I'm going to do my best throughout this conversation to contextualize that and to provide some nuance to some texts that can come off as pretty harsh. So the first text that I'm bringing is from the book of Exodus, chapters 21, verses 22 and 23. And this is often seen as kind of the cornerstone text that all of the rabbinic texts are kind of building upon. So in this situation, we're looking at what are the reparations if a woman is injured by two men who are fighting and loses her child. So here's the text. When men fight and one of them pushes a pregnant woman and a miscarriage results, but no other damage ensues, the one responsible shall be fined according as the woman's husband may exact from him, the payment to be based on reckoning. But if other damage ensues, the penalty shall be life for life. So in any situation, if there is some kind of physical altercation and someone is killed during that altercation, the price is life for life, right? So here, what this text is saying is if a pregnant woman gets caught in between two men who are fighting, interesting that it's the two men who are fighting and she kind of gets caught in the middle, and the miscarriage results, it's not seen as that the fetus has been killed and therefore the perpetrator is liable for capital punishment. However, the woman, the fetus is seen as a part of the woman's body. So it's essentially the same as if the man had broken her arm. So the reparations that he pays to her are based upon, what that damage would cost him, as opposed to a capital crime. Of course, this idea that losing an unborn child has a lot more emotional weight to it than simply breaking an arm or some other physical injury. But looking at it from a legal perspective, what the perpetrator would be responsible for is just the physical damage. The fetus is not seen as a human life. Next slide, please, Allie. So I'm now going to move into some rabbinic text, so Talmudic text, and some commentary on Talmudic text. And I'm bringing two legal principles. So the first one is this idea of WRJ-RAC imo, that the fetus is seen as the thigh of the mother. So in this text, Rabbi Yehuda Hanasi holds, a fetus is considered as its mother's thigh. In other words, a part of its mother's body. And it is as though the master transferred ownership of one of her limbs to her. So again, building off of this idea that we see in the Exodus text, that the fetus is seen not as a separate, independent being, human being, but rather as a part of the mother's body while it is in utero. We see some other examples of this legal principle played out throughout the Talmud. So in Yevamot 78a, we learn that a woman who is pregnant and is in the process of converting, if she converts before the child is born, the child is automatically considered to be Jewish, as long as the conversion happens before the child's born. Again, the fetus is a part of the woman's body. And in Yevamot 69b, kind of a difficult situation, but imagining a pregnant woman who is liable for capital punishment, the rabbis decide that if the woman's about to be executed, that they do not wait for the baby to be born unless she is already in the process of giving birth. Allie, if you could go to the next slide, please. So this text is a bit graphic, but it illustrates our second legal principle, which is the idea that the fetus is not a nefesh. So nefesh is a pretty fluid term, but means the breath, the soul, the life of a child. It's not a living being. So it's this idea of lav nefesh hu. So this is Rashi commenting on a text from the Talmud, Sanhedrin 72b. In the case of a pregnant woman who is in mortal danger during childbirth, she may extend her hand and cut up her fetus and remove it limb by limb. For as long as it has not emerged to the world, it is not a nefesh, or soul, and it is permitted to kill it and to save its mother. But if its head has emerged, one may not touch it to kill it, for it is as living offspring, and one does not set aside one nefesh for another. So, in other words, the physical health of the mother is of the utmost importance, it is her life that takes precedence until the child begins to emerge, in which case they are both the woman and the child are considered to be living beings, and it's not up to humans to decide which shall live and which shall die. In Yevamot, in the Talmud, we also learn that the fetus, until 40 days after conception, is considered to be merely water, right? So like very, very far from any ideas of conception being the moment that a child becomes, that, the fetus becomes a human being. The Talmud teaches that it's really just water at that point. Next slide, please, Allie. So in the previous text, we looked at a situation in which the mother's physical health is in jeopardy, and therefore an abortion is required in order to save her life. But an important question, and the one that is often in front of us today, is what about other circumstances? In what circumstances is it permissible from some Jewish perspectives to perform an abortion? And I first want to say that in Judaism, the principle of creating life is a fundamental value, right? The commandment to pru'urvu, to be fruitful and to multiply, is essential, as is the idea of saving a life, pikuach nefesh. We know that to save a life is to save the world. So abortion for convenience is, from many rabbinic perspectives, is not necessarily condoned. However, there is the question of the mental well-being of the mother. So while in the previous text we were looking at what happens to a woman when her physical life is in danger, this responsa from Rabbi Eliezer Waldenberg is answering the question about what does it, in what cases is it permissible for a woman to have an abortion if her physical or if her mental health is in question. So he says as following. So the situation is there's a mother whose child is going to be born with a disease that is going to inevitably lead to the child perishing within days, years, months, whatever it might be, but ultimately the child will die a premature death. And so the question is, in that situation, is it permissible for an abortion? And so Eliezer Waldenberg responds, "It is clear that in Jewish law, an Israelite is not liable to capital punishment for feticide. An Israelite woman was permitted to undergo a therapeutic abortion even though her life was not at stake," right? So it's not just about the physical perils. "This permissive ruling applies even when there is no direct threat to the life of the mother, but merely a need to save her from great pain, which falls within the rubric of great need. Now, is it possible to imagine a case in which there is more need, pain, and distress than the present one, in which the mother is confronted by the prospect of a suffering child whose certain death is only a few years away and nothing can be done to save it?" So what Rabbi Eliezer Waldenberg is saying is that the concern is actually less with the well-being of the child and more concerned with the well-being of the mother. Everything is kind of focused on the physical and mental health of the mother. So if there is, a situation in which the giving birth to a child is going to cause great emotional distress for the mother, it is permissible for that woman to have an abortion. But I think that what's most important is that the Jewish tradition clearly teaches against legislating what counts as anguish for the mother or what counts as great need. So the Jewish tradition does not say only in X, Y, or Z circumstances is this permitted, but rather really puts the decision and the choice in the hands of the mother to decide because what might cause mental anguish for one family might not cause mental anguish for another. And I think that's the real, thinking about when is a fetus considered to be a human being, and all those questions are important when thinking about the Jewish perspective. But I think the most important really is this idea that the mother's physical and mental health is of the utmost importance, and that is going to look different for each and every woman. Thank you.
Thank you, Rabbi Erdheim. That was very informative and really, I think, helps us set the stage for where we as a Jewish community, how we come to these issues, and from our faith and tradition perspective, how we look at the idea of abortion and abortion rights. So now I'm going to turn it over to Elizabeth Smith. For those who came on a little bit late, just a word about her title. She's the Chief Counsel for State Policy and Advocacy for the Center for Reproductive Rights, and as such has been working a great deal on this case. She's going to be providing us some background on the case itself and its implications, ramifications, and also some action steps that we can take. So Elizabeth, take it away.
Thank you so much. I also want to preface my remarks by saying that I'm getting a little bit of a cold, so if I have to stop and blow my nose, I apologize. Allie, we can go to the slide that has the map on it to start. So before I turn to June Medical, I just wanted to tell everybody on the call about a resource that my team at the center has recently updated and published, because outside of this case, it will give you a lot more information about what abortion rights and abortion access look like across the country. And so the project is called What If Roe Fell? The center first published it in 2004. And this new version of What If Roe Fell looks at both abortion rights and abortion access according to state law, the District of Columbia, and the 5 most populous U.S. territories. And we placed each state, territory, or the District of Columbia into a category based on a series of questions. So the first question we asked was, is abortion protected under state law? If yes, then we asked the question, has that state created greater access to abortion? If the answer to the first question was no, abortion is not protected under state law, then we asked a follow-up question, which was, has that state actually enacted laws and regulations that further create barriers to abortion access? And based on those questions, we then placed every state in a category. So looking at the states, I think some of you can probably tell what some of the categories may be. The states that are in blue are states that have expanded access. So that means abortion is protected under state law, and those states have created further access by allowing public funding for abortion, allowing advanced practice clinicians to provide abortion care. The yellow states are states that have protected abortion under state law, but still have some barriers to access. One of the most notable barriers is parental involvement laws. Then turning to the 2 red colors, the lighter red or the brighter red, those are states where abortion is not protected under state law, but there is access. And then the deep red states, probably unsurprising to most of you across the Southeast and the Midwest, those are states that we term hostile to abortion rights, where abortion is not protected under state law and access is difficult. So we can go to the next slide. And here you just see the number of states in each category. And so broadly speaking, the work of the state team at the Center for Reproductive Rights is to help more states move from hostile and not protected into protected and expanded access. We can go to the next slide. So I wanted to highlight again why we're still talking about the whole country before we zoom into Louisiana. I wanted to highlight this map to show you which states have either admitting privileges requirements, meaning that a provider of abortion care has to have admitting privileges at a local hospital, or these states have a requirement that abortion providers have either admitting privileges or a transfer agreement with a local hospital, or these states have just simply transfer agreements. So while those are 3 types of admitting privileges or transfer agreement requirements, you see that there are a number of states that continue to enforce these types of requirements. And these requirements fall under the category of TRAP laws, which TRAP refers to targeted regulation of abortion providers. So these requirements are ones that really only fall on providers who provide abortion care. There are not similar requirements for providers who, say, provide colonoscopies or various kinds of oral surgery, other types of procedures that are done in a provider's office. You can go to the next slide. So this is a timeline about one of our clients in June Medical Services, Hope Medical Group. So you see Hope Medical Group opened in Shreveport in 1980. And this timeline shows you some of the laws and regulations that were implemented in Louisiana. And I think you can imagine how some of these affected Hope, as well as the other providers that we represent in this case. I will direct your attention to the most recent spots on the timeline. So in 2014, Louisiana enacted an admitting privileges law. Louisiana saw how successful Texas was with their admitting privilege law in terms of closing clinics. And so there was a desire on the behalf of Louisiana lawmakers to enact an admitting privileges law and have that same effect in the state of Louisiana. Then you see that in 2019, again, because litigation takes a long time and litigation on abortion laws and regulations is no different. In 2019, the Supreme Court first granted an emergency stay, in this case to ensure that Louisiana could not start enforcing the law. And then later in 2019, in October, the Supreme Court granted cert, meaning that it decided to take the case. And you see that the date in 2020 is for oral arguments, which will happen on March 4th. We can go to the next slide. So the law at question in June Medical Services is Act 620. And as you see in the slide, Act 620 is identical to the admitting privileges law passed by Texas that the Supreme Court struck down in their 2016 decision, Whole Woman's Health. So what do I mean by identical? Well, first, both the Louisiana and Texas laws require an abortion provider to have admitting privileges at a clinic, or excuse me, at a hospital within 30 miles of the clinic where they perform abortions. And so what else is identical? Neither the state of Texas nor the state of Louisiana have been able to show there are any medical benefits to these laws. While both states passed these laws saying that they were beneficial to women's health, in the litigation, neither state could point to any benefits. And in fact, the trial court in both Whole Women's Health and in June Medical found that there were no benefits. What both courts found, the trial court in the Texas case and the trial court in the Louisiana case, what they both found is that there were significant burdens that these laws created. And so when we look at the question of, is Louisiana different from Texas? Our response is no, that we have seen abortion clinics close in Louisiana. And as the trial court found, there are no benefits and there are significant burdens. So you may ask, how did we get where we are? So in 2017, the district court in Louisiana found that the law was unconstitutional by applying precedent from Whole Women's Health, the Supreme Court decision from 2016. Then the state of Louisiana appealed that decision, and the case went up to the Fifth Circuit. And in 2018, the Fifth Circuit found that Act 620 was constitutional. And I think I've heard lots of people ask how that's possible. And what the Fifth Circuit said is that it was applying the test from Whole Women's Health, but it found essentially that Louisiana was different. And it found that abortion providers in Louisiana were not trying hard enough to gain admitting privileges. Now, the district court, when it created the record and created the facts, found that actually abortion providers in Louisiana were trying really hard to get admitting privileges. And while there are, different clinics in Louisiana, obviously, than there are in Texas, the situation was actually very similar. And in fact, to the question of, are providers in Louisiana trying still today to get admitting privileges? The answer is yes. Providers have been trying to gain admitting privileges since 2014 and still have been unable to. And this is a good time to say, too, that the decision from a hospital's perspective to grant or deny admitting privileges is typically a business decision. And it's based on whether the provider is going to send business to the hospital. And again, because abortion is very safe and leads to few complications, an abortion provider is not going to be sending a lot of business to a hospital's emergency room. The other thing to note is that because there are 3 abortion clinics in Louisiana, patients have to travel, in some cases, a long distance to get to the clinic. So the idea that a provider would need admitting privileges within 30 miles ignores the fact that if, in the very, very small number of cases where there are complications, if there are complications, that patient is likely well outside of that 30-mile radius by the time they have a complication. So the Fifth Circuit, as I said, declared Act 620 constitutional in 2018. In 2019, the center asked that the entire Fifth Circuit reconsider this question, and they declined to do so, and said that the law could go into effect, that Louisiana could start to enforce it. And so the center went to the Supreme Court and asked for an emergency stay so that Louisiana would not be able to enforce this law. And we were granted that stay. So while the law was enacted in 2014, it has never been enforced. So, as I said, later in 2019, in October, the Supreme Court granted cert. And so they are going to hear this case. And as I said, oral arguments will take place on March 4th. And we expect that a decision will come down from the court probably later in the term. A decision could come down after they hear the case at any point, but we think June is probably the most likely time when we will learn what their decision is. And we can go to the next slide. So what would the impact of Act 620 be in Louisiana? So what you see on the slide here is the number of clinics that used to be in existence in the state and how few are left today. So in 2001, there were 11, in 2014, there were 5, and today there are only 3 clinics left. And the map shows you the location of the 3 clinics. And as the slide says, if Louisiana was allowed to enforce Act 620, 2 of those clinics would close, and there would be 1 provider left in the state of Louisiana for approximately 1 million women of reproductive age. So, if abortion access is difficult in Louisiana today, it would become much more difficult if the admitting privileges law was enforced. I'll also add, looking at the map, you can see that the Shreveport Clinic, which is up in the far top of the state, that clinic serves patients from Louisiana, but it also serves patients from the neighboring states, from Texas, from Arkansas, from Mississippi. And so patients in those states who go to Hope Medical for care would also be impacted. And we can go to the next slide. So in addition to granting cert on the question of whether Act 620 is constitutional, the Supreme Court also granted cert on a question that Louisiana raised. Now, they did not raise this question at the district court level. They did not raise this question in their appeal to the Fifth Circuit. So this is rather rare, but this is a new question raised at the Supreme Court level. And essentially what they are asking the Supreme Court to decide is whether abortion providers have standing, just the ability to file a lawsuit, on the issue of abortion rights. So going back to Roe, Roe had plaintiffs, had an abortion provider and a pregnant woman as plaintiffs. And so from the beginning, the Supreme Court has allowed abortion providers to file lawsuits related to abortion restrictions and abortion laws. And so I think we can all imagine why this is the case. As I said earlier, litigation takes a long time. It takes a lot of effort to continue, to file a case, to go through all the process to get to a trial court decision, and then to go through any appellate process. So for a pregnant person who is seeking access to abortion care, if the pregnant person is denied access, I think we can all imagine the difficulties that person would have in, deciding to file a lawsuit to get access, hiring an attorney, going through discovery, essentially opening up their life to the opposition, and then having to spend a number of years litigating the case, even after obviously they did receive access to abortion care or they continued their pregnancy and had it filed. Because again, thinking about June Medical as an example, the case was filed in 2014 and it will be in front of the Supreme Court in 2020. So I think this this conditional cross petition, this question that Louisiana posed that the court is going to consider, is one that lots of people are interested in. I think there are lots of people who would like to read the tea leaves about what it means that the court accepted this question. And I simply can't provide you with an answer. I think once we get to oral arguments and we hear the questions that the members of the court pose, and we hear the way that Louisiana presents its case, and you hear the center attorneys present our case, maybe we'll have greater clarity on what it means. But if the Supreme Court decides, counter to nearly 50 years of precedent, as the slide says, if the Supreme Court decides that abortion providers and abortion clinics can no longer litigate abortion cases, it will become much more difficult to litigate these restrictive laws. The other and final thing I'll say here, but I'm happy to try to answer questions, is that the reason that Louisiana is, or one of their rationales for trying to say that abortion providers should not be the ones vindicating this constitutional right, is that abortion providers do not provide good care to their patients. And we absolutely know that that is not true, right? Obviously, this idea turns on abortion stigma that our opponents have used pretty successfully to, vilify people who seek to access abortion care, to vilify abortion providers, and to really stop even abortion supporters from having conversations about why we support abortion rights and abortion access. So again, more will come on this question, but the important piece to remember is that abortion providers and abortion clinics have always been able to litigate these cases, and that abortion providers have a much easier time doing so than abortion patients. So we can go to the next slide. And so then what's at stake outside of Louisiana? So you see on the slide that abortion precedents are in the crosshairs. And what that means is that Whole Women's Health in 2016 was a really great opinion, which basically said that abortion restrictions must have benefits, and those benefits must outweigh burdens in order to be enforced. And not only that, but there had to be evidence, both for the burdens and for the benefits. So under Whole Women's Health, a court is not supposed to just accept what a state says at face value. So Louisiana, for instance, said that the reason they enacted this admitting privileges law was to serve and further women's health. What the Louisiana trial court did was say, okay, we understand that's your rationale. What is the evidence that this law furthers women's health? And as I said earlier, there was no evidence. They could not show that there were any benefits. So again, Whole Women's Health was a really excellent decision, really instructing courts how to consider whether abortion restrictions were constitutional or not. The other piece is that, rule of law principles are under threat. So the Supreme Court decided a question 3 years ago that is identical to the question they'll consider in March. Rule of law principles mean that when the Supreme Court speaks and says what the law is, that needs to continue and cannot fall victim or cannot go by the wayside when there are political differences or the court changes composition. And then the third, as we saw on the previous slide, abortion access in Louisiana is definitely under threat. And so if the court comes down with a decision that Act 620 is constitutional and can be enforced, the sort of next day consequences will really fall on pregnant people in Louisiana, their families, and those in the state seeking bodily autonomy and the ability to decide if, when, and how they want to form families. Now, because we haven't had the argument yet and we don't know what the opinion looks like, there may be other consequences outside of Louisiana if the opinion is Act 620 is constitutional. We don't know what those could be yet, but in thinking about what that could look like, currently we have Whole Women's Health, which sets out a really good standard for how courts look at abortion restrictions. If the Supreme Court says that Act 620 is constitutional, they may also say something like, you know, they may rewrite their precedent to say, you know, to create a lower bar for when abortion restrictions can be enforced. We simply don't know. But I will say that we have hope that because Whole Women's Health was just decided 3 years ago, and because the laws are identical, we have hope that the Supreme Court will say, no, Louisiana, this is unconstitutional, you cannot enforce it. And we will argue that strenuously, but again, we will not know about the opinion probably until June of this year. We can go to the next slide. So, action opportunities. I'm glad that I have this opportunity to talk about these because there are times where I finish talking about June Medical and everyone is just destroyed. So, what can you do? We have a hashtag for the case, My Right, My Decision. So if you go into social media and type in that hashtag, you will hear from us, you will hear from our partners, and you will see some of the activities around the case where you live. There's also an accompanying website, My Right Decision, My Right, My Decision, which will give you more information about the case. If you are in Louisiana, there's a very exciting opportunity in New Orleans. 2 weeks from last Saturday, there are abortion advocates who are going to march in a parade called Chewbacca's, which is a sci-fi parade, and they are going to march under the banner of the Empowered Strike Back. And so there will be lots of witty Star Wars puns related to abortion access, with the goal of telling more people in New Orleans what is happening with the case and to get them involved. And then on March 4th, please don't forget this date, on March 4th, there will be a rally outside of the Supreme Court from 8 a.m. to probably 11:30. And we will rally outside of the Supreme Court for a couple of reasons. We are going to have speakers from Louisiana, from other states, from national partners, and they're going to tell the story of why abortion access is critical from their perspectives. And in addition to that, based on our strong showing and all of the stories that we tell from the podium, we want to let the Supreme Court know that we are watching, that we care about this case, that we care about the outcome of abortion access in Louisiana and also across the country. And so if you are anywhere close to DC or can get yourself to DC, we welcome you to join us. And again, if you go to My Right, My Decision, or if you put the hashtag into social media, more information about the rally will come up. So I hope to see you, although I'm not seeing your face now, obviously. I hope to see you in DC on March 4th. And there will be a simultaneous rally in New Orleans, also in support of June Medical. So if you want more information about either of those, if you contact Allie, she can get in contact with me, and as soon as we have save the date graphics for the rally, which will probably be later this week, I will send them to Allie so that they can get to you. We can go to the next slide. Happy to answer any questions that you may have to the best of my ability.
So actually, I'm going to stop the share right there just so that we can move into the Q&A portion for everyone. I see that we had one Q&A come in while Elizabeth was speaking. Please feel free to continue to use that Q&A or the chat function with other questions. I'm actually going to start off with a couple questions that we received ahead of time in the registration. So the first question is for Elizabeth, And the question is it lawful for the court to reverse itself on a decision? So the person who submitted this was specifically referring to Roe, but it can also have to do with whole women's health, since we know the cases overlap in so many ways. So what is your take on this?
So the Supreme Court has the power to determine what the law is in the US. And so while it's not a regular occurrence for the Supreme Court to reverse a case that has, almost 5 decades of precedent, it is absolutely within their power to do so. And I think, there are cases in history that were absolutely wrongly decided that were later correctly reversed. I'm thinking of things like Dred Scott, for instance, the case about enslavement. So they do have the ability to reverse themselves, but, and I think this is really important to remember, during the almost 5 decades that Roe has been the law of the land, the composition of the court has changed multiple times. And at every opportunity, the court has continued to confirm and reconfirm that abortion is a constitutional right. So while we are in a moment in time where the court is different than it was in 2016, the reason that we emphasize rule of law principles is to say that nothing has changed, that this law is identical, and the court should come out the same way that it did in the same way that it did in whole women's health.
Great, thank you. Okay, so we're going to switch to some of the live Q&As. Ronnie asks, are there other states surrounding Louisiana with more access to abortions? And if so, could there be agreements made to share their services with Louisiana residents?
Thank you for that question. The reason that I started with the What If Roe Fell map was to show how access to abortion is really threatened across the Southeast. In states surrounding Louisiana, like Mississippi, for example, in Mississippi, there's one abortion clinic. And so, yes, there are clinics in surrounding states, but none of the states surrounding Louisiana have what I would term, great access. And so what we're looking at, if Act 620 is allowed to be enforced, is a situation where pregnant people with means will be able to travel outside of the state and go somewhere else to get access to care. And people who are low income or who are experiencing other barriers will simply not have the ability, financial, logistical, etc., to travel to another state.
Thank you for that. So there are a few others. I'll just answer this right now, can we have access to both maps? Absolutely. The recording of this webinar will be posted in the WRJ Yammer and the URJ tent. And if you don't know what that is, I'm happy to email it to you as well. And the PowerPoints will also be in that recording and can be circulated. This is a broader question that I'm actually going to pose to Marla, given the fact that, as you addressed at the beginning, WRJ and the RAC have really been thinking broadly about what people can do to support reproductive health and rights from wherever they are. The question is, what can people do in states where our members are already supportive of reproductive rights? This can be for Elizabeth as well, but I'm going to start with Rabbi Feldman.
Sure, thank you. Well, the first thing to do is find out what the law is in your state and what accessibility is in your state, because even if it's legal, if there aren't clinics, then people don't have access. So from the local level, you can find out what support is needed at your local clinics, if there are local clinics. There are certainly sisterhoods, and I think some congregations that work as advocates for women and going into clinics with them, protecting people where there are demonstrations and so on, protecting women that are going into clinics. So there are things that can be done locally at the state level. In many states, you saw the map, so I would venture to say most states, legislation, even where it's legal, could be better. So for example, in Massachusetts, they're working to pass the Roe Act. And while Massachusetts law is, general blue state, nonetheless, if Roe v. Wade were overturned, it would still be illegal in that state. And so they are working to pass legislation that would protect abortion rights, even in the case that down the line Roe v. Wade were overturned. And so many of our congregations are very involved in a coalition in that state to pass what is called the Roe Act. So I think in a lot of states, there is positive legislation that can be supported. That happened very recently in New York. It turned blue. It wasn't blue. Was it 2 years ago, 3 years ago, in terms of protecting legislatively the right to access to abortion services. And then, of course, there are states where the advocacy is to prevent negative legislation. There's also, and I'll turn it over to Elizabeth because I'd like for you to comment on this as well. You saw the map and you saw where there is and isn't access. So even where we are in the landscape today, where Roe v. Wade still is the law of the land and it's legal, doesn't mean it's accessible. And there are women that are still traveling from states all over North America to, well, I shouldn't say North America because Canada's laws are pretty good right now, but they are traveling to states like New York where it's legal. And so there are financial needs. There are organizations that are working to help women that are traveling from one state to another to take advantage of what is their constitutional right. And for the most part, it is a poverty issue. Women who are living, who are vulnerable and living at their means don't always have the ability to take time off work, to fly to a different state, to pay top dollar for services that are not covered by Medicaid or by insurance. And so there are financial needs, and there are organizations that are working to fill those needs or to help women that are coming to their state, like in New York. So those are some of the things that I know of. Elizabeth, I'm sure you know of some other things as well.
I think your points are absolutely right. The great thing about advocacy at the state level and at the local level in the city in which you live is that one person or a small group of people can really, really make a difference. And so I would urge you to use What If Roe Fell to see what the laws are in the state in which you live, and then go to your representative, your state senator, and ask them to introduce a bill, or ask them to support a bill that's already been introduced, because your support to your representative or your senator can make the absolute difference. I think talking about abortion funds is really critical as well. Abortion funds are local, and they help pregnant people with a variety of burdens. They help with the cost of the procedure. They help sometimes with logistics. They help people figure out how to get transportation if there is not a clinic in the city in which they live. And at the local level, there have been some cities that have done pretty interesting things to support local abortion funds. So the city of New York, in this year's budget, put $250,000 into the budget as a grant to the local abortion fund. The city of Austin, Texas, is not allowed per Texas law to support abortion providers, but what they decided to do was put money in this year's budget to support their local abortion fund, which doesn't cover the cost of procedures, but covers the cost of transportation and logistical support. So find out what is happening in your state or your city, and you can absolutely have an effect at the state and the local level.
Great, thank you. So this next question is really great. We talked a lot about the implications of letting Act 620 go into effect and what type of effect that would have in terms of Louisiana specifically, but what would the implications be for other states? Do you think we would see similar legislation being introduced or even going into effect immediately?
So one of the striking things about the moment in which we're living is that anti-abortion lawmakers are no longer satisfied with implementing abortion restrictions. They have really turned their attention to abortion bans, to early gestational bans, and other types of bans. And so there is absolutely the possibility that a decision in June Medical that allows states greater leeway in implementing restrictions might lead to more restrictions. It might also just lead to more early gestational bans or more total bans like the one that Alabama passed last year.
Great. I mean, not great, but thank you for answering. So yeah, as we can tell, the implications would be severe for Louisiana, but pretty scary time for the rest of the country as well. So this is going to be our last question. In the interest of time, I'm going to attempt to combine a couple of questions. If you did not have a question that was answered, please feel free to reach out to me at the end of this. My email was in your registration link, but it's Karpel, Karpel @rac.org. And I'm happy to connect you with Elizabeth, with Rabbi Feldman, with Rabbi Erdheim. So the last question, I know a lot of people are not in Louisiana and they're not in DC or a neighboring state. Are there going to be rallies in other states, and what can folks do specifically regarding this case if they don't live in Louisiana or near DC?
So we at the center, we are trying to keep track of all of the other rallies or events that are planned. But I would say if there is not one planned where you live, plan one, right? Get a group of people together, have a rally, take pictures, put them on social media, use the hashtag. And again, use that as a way to kickstart some advocacy efforts where you live. Invite you to either join one that's in existence and we can help get information to you, or I would absolutely invite you to plan and host a rally. Even if it's you and 3 friends, that's still more than would have happened without you. So please do think about just planning one for yourself.
Great. All right, I'm going to share my screen. Oh,
yeah,
Marla?
before you share your screen, I just want to, before you close us out, Allie, thank our speakers, Rabbi Erdheim and Ms. Smith. Thank you very much. Allie is going to close us with some additional action steps. But I interrupted because I want to also thank Allie. What she's been able to do with this position and how she's been able to engage the reform movement from state to state to state has really been remarkable. And I would encourage you, there were some questions about what's going on in a particular state. Allie is there at the RAC for that purpose. So if you want to know what's going on in your state, you want to know who your potential coalition partners are, if there's going to be rallies, Allie's your gal. So I wanted to especially thank Allie for all the work that she's been doing on this and the full range of issues having to do with reproductive health and rights. So thank you for the important work you're doing, Allie.
Thank you, Marla. Okay, so let us wrap it up. Okay, great. So as Elizabeth mentioned, I just wanted to highlight that the RAC and WRJ will be participating in the rally in Washington, D.C. in front of the Supreme Court, absolutely. And I mentioned New Orleans just because I know that that'll be another big one. So if you are interested in attending these rallies, more information will be coming to you in the coming weeks. I will send out an email to everyone who registered for this webinar once we have more concrete details about where the reform movement, where our meeting spot will be, and other details like that. But we definitely want to have a strong showing from everyone in the reform movement to show that Reform Jews support abortion access. Next, I just want to quickly highlight the reproductive health and rights cohort. So as Rabbi Feldman mentioned at the beginning of the call, WRJ and the RAC have been working in partnership to launch this reproductive health and rights campaign. And one of the key highlights of this campaign is the cohort. which is a virtual network of communities. We currently have nearly 40 sisterhoods or congregations and 80 individuals signed up to this cohort. We meet monthly online, and it's really a space to share what your community is doing around reproductive rights, share successes, share challenges, learn from experts. So if you enjoyed hearing from Elizabeth and Rabbi Erdheim and Rabbi Feldman today, if you join the cohort, you'll be granted access to monthly learnings from Jewish experts and reproductive rights experts. You can learn more about the cohort at rac.org/BritOlam. Even if you don't join the cohort, there are still plenty of opportunities to get involved with the campaign. We have a toolkit at WRJ.org/repro and rac.org/repro. They're identical. And these are meant to be resources and toolkits to help kickstart your advocacy efforts. Even if you don't join the cohort, it gives some clear ideas of key coalition partners. I know there were some questions about who do we partner with, who should we reach out to. Many of that is outlined in the toolkit. Next, I just wanted to highlight a really amazing opportunity for anyone who identifies as a female. You can register for the Freed Women's Conference in Phoenix, which is really, really exciting. I'm coming at you from Washington, D.C., so I'm very much looking forward to going to Phoenix April 30th through May 3rd. It's going to be a really amazing conference to develop your leadership skills, participate in issue-based workshops, including reproductive rights, and a whole list of others, and more. And then finally, I just wanted to highlight the Reform Movement Civic Engagement Campaign. We know how important the 2020 election is for all the issues that we care about, including reproductive rights. And so we launched the Civic Engagement Campaign at the RAC's Consultation on Conscience this past May, and are really building out this movement. We really hope that you participate, and you can find more ways. You can learn how you can become involved in this Civic Engagement Campaign throughout the coming months. There will be a training this coming Thursday at 8 p.m. Eastern, and I'll send out the registration link in the follow-up email. And it's really meant to be a way to figure out how your community can become involved, whether it's your congregation, your sisterhood, and how we can work together to promote values that we care about. That is the end of our webinar. Thank you again to all three of our panelists. Thank you all for joining. And I hope to see you at a rally on March 4th and at other events. Thank you.
Thank you, everyone.